So my title is Conservation, Crime and Pangolin Poaching, Tensions Between Customary Use and Conservation Efforts. So I think it's worth asking the question, what are pangolin? Because a lot of people don't know. So pangolins are toothless ant-eating mammals endemic to regions of Asia and Africa. The animal is protected by overlapping keratinous scales, which account for approximately 20% of its body mass. When threatened, a pangolin's defense mechanism involves curling into a tight ball by tucking its head beneath its strong muscular tail. And there are 8 species of pangolin across both Asia and Africa. But the focus of my LLB research is the Temminck's pangolin, or Smutsea temminckii, endemic to South Africa. There are numerous anthropogenic factors that are threatening Temminck's pangolin populations, with some rooted in poverty and need and others in profit and greed, including but not limited to transnational organized wildlife crime, with pangolins termed the most trafficked mammal you've probably never heard of. And it's estimated that upwards of 1 million pangolins have been trafficked in the last decade. Another anthropogenic factor that's threatening Temminck's pangolin populations is electrocution by electric fences, traditional, medicinal, or muti use, the bushmeat trade, road mortalities, and habitat loss. So my main research question aims to prove that the South African laws governing pangolin conservation impose limitations on customary usage and access to pangolin. My dissertation assesses the interplay between African customary usage of pangolin and the mainstream conservation laws, and to what extent the existing legislative framework undermines the heritage value of pangolins for customary communities. And it bears mention that the term customary communities is used to denote communities who regulate their lives in terms of customary law. And my research question is two-pronged. So firstly, to what extent do the laws governing pangolin protection in South Africa impose limitations on customary usage? And secondly, can or should customary law rights of access to and use of pangolin coexist with mainstream conservation efforts? So pangolins are utilized traditionally for the treatment of various physical infirmities and spiritual antidotes. Despite a relatively sparse body of literature in this regard, a recent ethnozoological survey of the traditional uses of Temminck's pangolin operates as a useful tool in ascertaining the significance of the animal across South Africa. This survey was conducted in 4 out of the 9 provinces, with participants from a number of communities in South Africa. The survey concluded that the Temminck's pangolin is still highly sought after and used regularly in traditional medicine and divination in South Africa. Therefore, many South African communities are engaged in legitimate customary use of pangolin, which constitutes an integral part of cultural beliefs. So the place of pangolin within South African law, I've divided it into 2. So the laws regulating pangolin conservation on the one hand, and the laws regulating pangolin use on the other. So with regard to conservation, Section 24 of the Constitution, which enshrines the right to an environment, NEMA as framework environmental legislation, NEMBA, the threatened or protected species regulations, a plethora of provincial legislation governing pangolins, and then South Africa's international obligations under the Convention on the International Trade in Endangered Species. And then with regard to the laws regulating pangolin use, there are no laws that I'm aware of that directly regulate use, but laws that potentially regulate pangolin use are Section 24, Sections 30 and 31 of the Constitution pertaining to the right to language and culture and cultural, religious, and linguistic communities. Section 211 of the Constitution, which provides for the recognition of customary law, NEMA again, and the Traditional Health Practitioners Act. So pertaining to my first part of the research question, to what extent do the laws governing pangolin protection in South Africa impose limitations on customary usage? I assert that the general approach to South Africa's conservation laws can be described as fortress-oriented, in that the interests and traditional practices of customary communities are excluded by imposing restrictions and extensive penalties on access to and use of many natural resources, including pangolin. Evidently, the simultaneous practical realization of the protection of pangolin and customary usage are at odds, because although there is an extensive body of legislation regulating the conservation of pangolins, there are no laws directly regulating their use. So whilst some very limited customary usage ought to be permitted, the mainstream conservation laws inhibit legitimate customary use insofar as there are currently no legally protected uses thereof. But notwithstanding the absence of direct regulation, NEMA contains various indications that a more inclusive custodianship approach should be adopted through the inclusion and participation of customary communities in pangolin conservation. And then with regard to my the second part of my research question about can or should customary law rights of access to and use of pangolin coexist with mainstream conservation efforts, you'll see that I have further divided it into two. So on the question of can coexistence occur, the possibility and justifiability of coexistence depends on whether the access to and use of pangolin constitutes a reasonable and justifiable limitation of the right to an environment in terms of Section 36 of the Constitution. And a judgment that is instructive in answering this question is the Gongose and others versus Minister of Agriculture, Forestry and Fisheries, in which the Supreme Court of Appeal allowed for the exercise of a customary right to access and use of forest and marine resources in a marine protected area in the Eastern Cape. So I've relied on this judgment to outline the similarities and differences between the exercise of a customary right to fish and a customary right to pangolin. But then on the question,
Nicola, won't you just check your mic? It sounds as if there's a woodpecker who's joined us in the conference. And
yeah.
it's definitely coming from your speaker. So won't you just check that there's no woodpecker around your
Sorry, I don't know why that is.
It could just be something rocking, but let's continue.
Is it better now or not?
Yeah, it just comes and goes. It could just be your computer rocking on its cradle or something in the background.
Sorry about that.
No problem. Sorry to interrupt.
I don't know why that is.
We were losing some of your key content, but let's continue.
Okay. Sorry. But on the question of should customary law rights coexist with mainstream conservation, this brings to the fore the question of desirability of coexistence by considering overarching conservation objectives and various ethical considerations, such as would the consumptive use of pangolin by customary communities undermine their intrinsic value, and also considering the scale of the transnational illegal wildlife trade, how could internal regulations pertaining to consumptive use of pangolin ensure that wildlife trafficking does not masquerade for legitimate customary use? And then on my concluding slide, the potential coexistence of mainstream conservation laws and customary law. I assert that the Traditional Health Practitioners Act may provide an avenue for customary usage through the requirement of registration to practice as a traditional health practitioner. According to Section 21 of the Traditional Health Practitioners Act, no person may practice as a traditional health practitioner unless they are registered. So this may provide an avenue for coexistence. And although NEMBA, the Threatened or Protected Species Regulations and CITES envisage no use of pangolin by customary communities whatsoever, a person who is registered as a traditional health practitioner could potentially rely on the custodianship-oriented provisions in NEMA to facilitate the customary use of pangolin. And in closing, I propose that the potential for harmonization between mainstream conservation and customary law exists in the African philosophical adage of Ubuntu, to the extent that it embodies the principle of wholeness between human beings and physical nature. Thank you.